In this episode, I would like to discuss about a comparative study between the maintenance pendency light, permanent alimony under the Hindu Marriage Act 1955 and maintenance under section 125 of the Code of Criminal Procedure 1973. We know that section 24 of the Hindu Marriage Act, it deals with the maintenance pendency light, and section 25 deals with permanent alimony. Similarly, section 125 of the Code of Criminal Procedure deals with the provision of maintenance. Today I will like to discuss about what are the similarities between these provisions and what are the differences between these two. Section 24 of the Hindu Marriage Act deals with the maintenance pendency light and section 25 deals with the permanent alimony. Similarly, section 125 of the Code of Criminal Procedure, it deals with the provisions of maintenance. So, let us have a look that a comparative study of alimony under the Hindu Marriage Act 1955 and maintenance under the Code of Criminal Procedure 1973. The Hindu Marriage Act 1955, section 24, maintenance pendency light and expenses of the proceedings, and section 25, permanent alimony. Similarly, the Code of Criminal Procedure 1973, section 125, order for maintenance of wives, children and parents, and order of maintenance and order of interim maintenance as granted by virtue of section 125. So, first I will discuss about what is the ingredients of section 24 of the Hindu Marriage Act 1955 that deals with the provisions of maintenance pendency light. Section 24 of the Hindu Marriage Act 1955 deals with the maintenance pendency light and the expenses of the proceedings. That means, if during any proceedings under the Hindu Marriage Act, if the court is satisfied that either spouse has no sufficient means to bear the expense of the proceedings or cannot support themselves, then the court may pass the order directing the respondent that respondent is to pay to the petitioner the money for necessary expenditure of the legal proceedings as well as for support of the petitioner. So, court will pass this order taking into consideration that what are the incomes of the both sides, either of the husband or the wife, and the order must be passed within 60 days from the service of the notice to the other side. So, let us have a look the ingredients of section 24, that is maintenance pendency light and expenses of the proceedings. So, for ingredients are concerned, there are three ingredients. First is, if either spouse has no independent income for support and expenses of the proceedings. That means, either husband or wife has no sufficient income to support himself or herself and cannot bear the expenses of the proceedings. Secondly, monthly sum will be ordered by the court having regard to the income of the spouses. Court will grant the order of means to the tune of money, means what will be the quantum of the money, that will depend upon the income of the spouse. What is either income of the husband or wife, that will be taken into consideration by the court while granting relief under this section. And application will be disposed of within 60 days from the date of service of the notice. Within 60 days, the application is to be disposed of. Now, I would like to discuss about section 25 of the Hindu Marriage Act 1955 that deals with the permanent alimony and the maintenance. So section 25 deals with the permanent alimony and maintenance. It provides that if the court is satisfied, then court can direct the petitioner that he will be granted the permanent alimony, that means the periodical sum which is to be paid by the respondent in favor of the petitioner during his lifetime, so long he or she will survive. Periodical way or in monthly basis, he or she will be paid by the other side such amount which will be considered reasonable by the court, and court will have regard about the incomes of the either spouse. Court will consider the income and the property of the petitioner and respondent both, and then court will grant the order of the permanent alimony which is to be paid periodical basis or in a monthly basis by the respondent to the petitioner. So let us have a look that section 25, that is permanent alimony and maintenance. Ingredient said, while passing any decree, monthly or periodical sum not exceeding life of the applicant, and court will have regard to the income and property of the spouses. And not only that, when the order is passed by virtue of section 25 of the Hindu Marriage Act, it can be altered or modified, or it can be rescinded by the court if there are changes in the circumstances, or if any of the spouse had married again, that means remarriage, or if the wife is becoming unchaste, means unchastity is a ground of modification of the order, or if the husband has some illicit relationship with the other woman, means not within the matrimonial wedlock, out of the matrimonial wedlock their husband is keeping some sexual illicit relationship with the other woman. So the order which is passed by virtue of section 25, that means permanent alimony, it can be modified or altered if there is any change of circumstances, or if the wife becomes unchaste, or if there is any remarriage on the part of either of the spouse, or husband keeping some illicit relationship, sexual relationship with some other person which is out of the wedlock. So these are the grounds of changes, modification or alteration of the order under section 25. Now I am discussing about section 125 of the Code of Criminal Procedure 1973, which deals about the maintenance. According to section 125 of Code of Criminal Procedure, in a brief manner, that it can be applied by the wife or son or daughter, whether legitimate or illegitimate both, or by father and mother against any person. So 125, it deals with the claim of maintenance which can be applied by either wife or of any person against the husband, or by parents against the son, or son and daughter also make the application against their father for provision of the maintenance. And so long it is pending, like alimony means maintenance pendenti lite by virtue of section 24 of the Hindu Marriage Act. Similarly here, interim maintenance can be granted by the court till the disposal of the application. And here also the interim maintenance is to be passed during the pendency of the proceedings, positively within 60 days from the date of service of the notice to the other side. And not only that, it is stated there that no order of maintenance can be granted by virtue of section 125 of the Code of Criminal Procedure if in favor of any wife, if the wife keeps the adulterous relationship with someone else, if the wife is guilty of adultery, or if the wife is staying outside, not keeping in touch with the husband without any reasonable excuse, she is not staying with the husband without any reasonable excuse, or they are residing separately by mutual consent, then court will not grant the order of maintenance in favor of the wife. And not only that, if either of these three grounds is proved, that means if the wife keeps adulterous relationship, that means she is guilty of adultery, or there is no reasonable ground for residing without husband, or they are residing with mutual consent, so court can also modify or cancel the order. Court has the power to cancel such order if any of the ground is proved. So let us have a look that section 125, order of maintenance of wife, children and parents. So ingredients are wife, child, parents, either of them can apply. Application is to be made before the magistrate of the first class. Interim maintenance also can be allowed by the court, and interim maintenance to be allowed within 60 days from the date of service of the notice. And no order in favor of the wife will be passed if there is the ground of adultery or residing without sufficient reason, and also living separately by mutual consent. And not only that, court may cancel the order also for any of these reasons. So these are the essential ingredients of section 125. Now I would like to discuss about the basic differences between the nature of alimony and maintenance application, that what are the basic distinction between the application of maintenance under section 125 of Code of Criminal Procedure and alimony under the Hindu Marriage Act. So far the alimony is concerned, section 24 and 25 of Hindu Marriage Act, it can be applied by either spouse. It is the first point of distinction, that alimony can be applied either of the spouse, either husband or wife, both are entitled to claim alimony against the other spouse. Whereas section 125 of CRPC says that only wife is entitled to apply against the husband for claiming the maintenance. Husband cannot claim against the wife. And second point of distinction is this: section 25, its scope or ambit is narrow because it is confined within the spouses only. Only husband or wife can make the application against the other spouse, whereas section 125 of the Code of Criminal Procedure, its ambit or scope is much more broader because it is covering the ailing parents, sons and daughters, offsprings, and wife. So either the wife or son and daughter, whether legitimate or illegitimate, or even ailing parents, they are entitled to claim the maintenance under section 125, and husband is completely disallowed to claim. And next point is that so far maintenance under section 125 of the Code of Criminal Procedure is concerned, its proceeding is quasi-civil, whereas alimony under Hindu Marriage Act proceeding is purely civil in nature. So proceedings under section 25 of Hindu Marriage Act, it is purely civil in nature, whereas proceedings under section 125 of Code of Criminal Procedure, it is quasi-civil, because some features of criminal proceedings are related with the 125, because if any husband refuses to pay the maintenance even after the order, warrant can be issued, whereas the remedy in case of alimony under Hindu Marriage Act, only it can be enforced by the decree of the civil court. And in case of alimony under Hindu Marriage Act, strict proof of marriage is necessary, because it is to be established that they are the spouses. Whereas in case of section 125 of the Code of Criminal Procedure, strict proof of marriage is not essential. It is not sine qua non or indispensable things. Means if they are residing, though their marriage is not established, but still the wife is entitled to claim the maintenance against the husband, though there is no strict proof of the marriage. So these are the basic differences between the two provisions. So let us have a look that alimony under Hindu Marriage Act and maintenance under CRPC. So first is either spouse can apply, that means both husband and wife may apply. But here only wife can apply, but husband cannot apply, it is limited. Second is scope is narrow since it is related only between the spouses, whereas it relates with scope is broader since parents, offsprings, that means the children, spouses, all are concerned. Third is it is purely civil in nature, civil proceedings, whereas it is quasi-civil. And last is strict proof of marriage is necessary, whereas in maintenance, that is strict proof of marriage is not necessary. So these are the basic distinctions between the two. Now I would like to discuss about what are the determining factors in case of application of the maintenance. That means what are the factors upon which it will be determined the quantum of the maintenance. That is, now first is that court will consider that what is the source of income of the petitioner, or if there is any source of income of the wife or the parents, as the case may be in case of 125 of the Code of Criminal Procedure. So income will be considered by the court of law while deciding the amount or quantum of the maintenance. And next, whether it is of the petitioner as well as of the opposite party. Next is that what is the status of the parties, that means what is the status of the petitioner and the other side, and what are the necessary expenses. That means necessary expenses means the expenses relating to the food, clothing and shelter of the both parties. And last but not the least, that is the number of the family members. What are the number of the family members of the parties? These factors are to be considered by the court of law. So that's why it is written that source of income of the petitioner, basic determining factors regarding the quantum of maintenance, source of the income of the petitioner, source of income of the opposite party, status of the parties, necessary expenses of food, clothing and shelter of the petitioner, and number of family members of both parties. Now I would like to discuss about one question, that whether the application for alimony under Hindu Marriage Act or maintenance under Code of Criminal Procedure, whether they can run simultaneously. That means a person has applied under Hindu Marriage Act for seeking the relief of alimony, and simultaneously he has applied for seeking the maintenance, whether both can run. That means whether application under section 125 can be considered as a bar for filing the application under the Hindu Marriage Act for means alimony under section 25, or whether section 25 application can be a bar for making the application under section 125 of CRPC. That is a relevant question, but there is no such bar, because both can run simultaneously if any party has already applied for seeking the relief of alimony by virtue of section 25 of the Hindu Marriage Act. It will not create any bar for making the application under section 125 of the Code of Criminal Procedure. Similarly, an application under section 125 will not create any bar for proceedings under section 24 or 25 of the Code of means Hindu Marriage Act. So both can run simultaneously, but if any order already passed in any alimony proceedings, then when court will grant any relief, under section 125 of the Code of Criminal Procedure, court will consider the earlier order, what was the amount granted. So, court will pass the order keeping in mind what order is passed by the other court. So, similarly, if any order is passed by section 125, maintenance order is passed. So, when court will give any decree in the application of section 25, court will consider that what amount already passed by maintenance section 125. So, court will consider and then court will pass. So, it is written there that proceedings of alimony under the Hindu Marriage Act 1955 and maintenance under CRPC can run simultaneously, but the court will consider of the amount granted by any court in either proceedings. Now, I would like to say in a very brief manner that section 125 of the Code of Criminal Procedure is complying with the Article 15 Clause 3 of Constitution of India. Means, as a constitutional perspective, it can be said that 125 is complying with Article 15 Clause 3 of Indian Constitution. That means, state can make some special provision for the interest of women. So, Article 15 Clause 3 state nothing in this article shall prevent the state from making any special provision for women and children. So, here also in section 125 only wife can claim the maintenance against the husband is not allowed. So, wife is getting the advantage to apply against the husband. Finally, I would like to discuss about two judgments, one relating to section 125 of the Code of Criminal Procedure, that is MST Jagir Kaur versus Jaswant Singh, AIR 1963 SC. Here Supreme Court stated that section 125 proceeding is civil in nature and remedy is summary. And another judgment, that is Jasbir Kaur Segal versus District Judge Dehradun, AIR 1997 Supreme Court, it is stated that meaning of section 24 cannot be restricted to wife alone, and maintenance claimed may include her own maintenance along with that of the daughter, means any child, and no separate application is to be required under section 26. So, it is stated that MST Jagir Kaur versus Jaswant Singh, AIR 1963 SC, that section 125 proceeding is civil in nature and remedy is summary. And in Jasbir Kaur Segal versus District Judge Dehradun, AIR 1997 SC, it is stated that the meaning of section 24 cannot be restricted to wife alone, and maintenance claimed may include her own maintenance along with her children. So, I have discussed the relation between section 24-25 of the Hindu Marriage Act as well as section 125 of the CRPC, what are the ambits of them and what are the differences between the provisions.